This is case 2022-0483 in the matter of Amy Froebel Fisher and Richard Fisher.
Morning, Attorney Gordon. I understand you reserved 2 minutes.
May it please the court, I'm Joshua Gordon. I represent Amy Froebel, who's here this morning, and I've reserved 2 minutes. Parties signed out-of-state stipulations for an uncontested divorce, and the court had jurisdiction questions, held a hearing, and found jurisdiction was okay. The court also perceived potential problems with the stipulations, so scheduled a review hearing for, it said, to explain the basis of the steps. If the steps were rejected, this should have reverted to a standard contested divorce. Instead, the court skipped to the end, issued a cookie-cutter decree, dissociated from the parties' circumstances and their intents, and with little support in the record. But even if the stipulations were not fair enough, they did implement the parties' intents. While the family court is nominally entitled to deference, these parties had specific intents, both with regard to parenting and with their financial issues. Regarding the parenting step, RSA 461A grants parents the widest discretion in developing a parenting plan. These parties trust each other's parenting, and where they clearly wanted flexibility, the court imposed rigidity. While the court's parenting plan is not unreasonable in the abstract, it does not reflect this family's needs. Regarding the property step, while equal is presumed equitable, like the court said, equity does not demand equality. Amy took on $500,000 of debt. He walked away debt-free. Together, they saved the house for the child and ensured funding for her education. Maybe there are other creative ways to implement their intents that the court would find fair. On parenting, maybe visitation for a certain number of days per year. On property, maybe a time buyout or a trust or something. If the case were subject to the standard process, there would have been opportunities for the parties to perhaps discover something that the court would approve. At the beginning of the review hearing, and I urge you to read those few pages carefully, there was lots of confusion regarding what the hearing was about. Amy's lawyer painstakingly clarified the purposes. The court denied that it had already decided that the steps were unfair, and thus the purpose was to determine whether the steps were unfair. But whatever the review hearing was for, it clearly was not a final divorce hearing.
Now, didn't the trial court ask the parties on multiple occasions whether another hearing was necessary, needed, or wanted?
I think the court mentioned the fact that there might be hearings later, and the lawyer didn't say, well, schedule one, but I think the lawyer assumed, because this was a review hearing, that if this turned into a contested divorce by disapproval of the steps, then there would be a divorce process, the regular process with discovery and mediation and so forth following that. So it's not really a surprise that the lawyer didn't jump up and say, let's schedule that right now. He assumed naturally or reasonably that it would just occur in the normal course. But whatever.
Had any discovery been conducted by the parties?
None. No, in their stipulations, they waited.
Is it your position that the trial court was bound to accept the stipulation?
Well, that's within the discretion of the court.
And the court has the discretion to reject the stipulation.
The court has the discretion to reject them. I think that my client would prefer that they be enforced, but if they're not going to be enforced, and I think that's probably where we are today, then there should be a divorce hearing, a final divorce hearing with notice that says something like final divorce hearing. And the court issued this decree after this review hearing, without any final hearing, and imposed this generic plan that, I don't know, it seems like a very standard, normal plan, but it doesn't really fit the parties. And for example, the court ruled on whether Richard's brother's place in Saugus was available for visitation with the child, but we don't know anything about that. We don't know whether this is an efficiency with a couch or whether it's a 10-bedroom manor with an English garden and all the amenities. And we don't know anything about the brother, whether he's established and settled or whether he's shifty and transient. Yet the court ruled on the matter. The point is, the court made assumptions unjustified by the record, after what was apparently a final hearing, which was advertised as a review hearing on the STIPs.
Am I right that both the husband and wife testified at the hearing?
They did. They did.
And
Both sworn.
and what were the arguments that counsel would have made on behalf of the wife that were not advanced at the hearing?
He would have brought up numerous issues. There was adultery going on. He was involved in alcohol and drugs. There was a dissipation of the marital estate. I think that would have been among the issues that he would have brought up, or that she would have brought up, had there been a divorce hearing. But the point is, the court made all these assumptions. The court asked, it was almost inquisitorial, like the European system, where the judge asked the parties questions, but there was no cross-examination, for instance. And that's legal error, and it's beyond the court's discretion. This court should reverse and remand to either enforce the stipulation or have a contested divorce procedure. I want to address preservation because my brother raised it. This court has encouraged broad questions and has penalized appellants whose questions are too specific. Amy's notice of appeal question broadly encapsulates issues I've argued in my briefs, including inadequate notice, eclipsing the standard review process, divorce process, issuing a decree irrespective of the parties' intents, and making findings based on assumptions rather than evidence. If there's no more questions, I'll take my seat.
Attorney Gordon?
Notice is before you walk into the courtroom, and these are old cases. Morphy is in 1972, and that's where a contempt hearing was noticed, and it turned into a child support hearing. Douglas is in 1999, which enunciated the due process issues.
Old is a relative term, Mr. Gordon.
Pardon me?
Old is a very relative term. But your client certainly had the opportunity to call a halt to the proceeding and state on the record that further hearings would be necessary, or evidence would be necessary, or call the opposing party, not counsel, party to the stand, or your own client to the stand. All of those opportunities were available, correct? Or
Had
not?
the opportunity,
Yes.
but there's two things. One is, I'll refer you to Reardon and Lemoyne that says an opportunity to present evidence doesn't cure the notice issue, but also it's not clear from the record, and I've read that transcript over and over. It's not clear. At some point, this hearing morphed from a review hearing into, I guess, a final divorce hearing, but you can't really tell when that happened. And the court was asking questions, and you don't really know why. And the result, when you get to the order, is just plain surprising. And that's how my client's lawyer felt about it. It's like, wait a minute, they did not expect a final divorce decree from this hearing, and that's the problem. And if just during the hearing, it is not discernible that the hearing had actually morphed. Thank you very much.
Thank you, counsel. The case is submitted.